I, Anshmi Malu, student of fourth year, hereby welcome you all on behalf of Unitedworld School of Law to this webinar on emerging concepts in digital privacy law, a look at emerging trends and challenges facing by tech-based companies. Before we move forward with the session, I would like to give a brief introduction on our today's guest speaker, Mr. Peter Browne. Mr. Peter Browne possesses nearly 20 years of academic and administrative experience in prima global institutes located in Ireland, China, Europe, Thailand, Slovakia, etc. He, being an alumni of law program of University of London, has contributed to the global legal field with his research skills in academics as well as corporate sector. Mr. Browne is well acclaimed globally for his contribution in the field of career counseling and guidance. Also, his scholarship of emerging concept in digital privacy law, a look at trends and challenges facing by tech-based company, has been reflected in his writings, and we are glad to have him with us today. Now, I would request Mr. Sood, sir, Assistant Professor of Law, to address you all. Thank you.
Thanks, Anshumi. I just want to welcome Peter sir on behalf of Unitedworld School of Law, Karnataka University. We are delighted to have you here, sir, and your words of acumen will definitely benefit almost all of us. We have our students joining right now, just like 20 students are there, but then we shall have some more students also joining in. So if we can just start, but we can start with the sessions. Over to you, sir. Thanks, Anshumi.
That's fine. That's brilliant. Yeah, thanks very much. Thanks very much for your introduction, Shrut and Anshumi. That's yeah. So just a little bit about myself. So I'm originally from Ireland, and at the moment I'm teaching in Tashkent in Uzbekistan, but physically I'm in Spain because of the coronavirus. So it's limited people's movements. I suppose digital privacy is a very interesting area of law because within the European Union, and especially in Ireland, privacy laws have had a huge impact. So a little bit about Ireland, just a little bit about the background of Ireland, and then I'll get into my speech. So Ireland was quite, it wasn't a well-off country. And then in the 1990s, the government started to attract foreign direct investment from the United States. Because it's an English-speaking country, has low corporation tax, a lot of big tech companies moved into Ireland. So most tech companies in Ireland have their European headquarters there. So Facebook, LinkedIn, Google, Microsoft, all these countries, so all these companies. So the GDPR laws that we're going to look at a little bit today have had a really big impact on the way that tech companies are going to operate in the European Union. And it's a very interesting area of law. So I'm just going to share the presentation and we'll go through it. So what we're going to do in this talk is we're going to look at the concept of privacy as a legal concept and the evolution of privacy law, okay, the GDPR and its effect, new waves in American law and what it means for the legal profession. Okay, so just quickly, I suppose many of you have already heard of GDPR. So let's look at what privacy is. Okay, so I'm going to show you a picture. I think this kind of, for me, encapsulates the different approaches to privacy. Okay, so what is privacy? So when I first went to China, I used to teach in a school, and this was the bathroom in the school looked very similar to this. Now I'm coming from Ireland. I'd never seen a bathroom like this where there was no doors on the front of the toilet. Okay, so for the culture that I grew up in, this kind of privacy was just accepted, that you'd always have a door on your bathroom, on your toilet. But obviously, what I really realized quite quickly is there's different concepts of privacy around the globe. And what might seem as quite normal for one person is completely the opposite. And this is what's quite interesting about the privacy laws that are now being enacted is, are they universal? Where do they come from? Where did this idea of privacy come from? Okay, if you go back 150 years, really, there wasn't much of a concept of privacy, okay, there were, legally anyway. But there was certainly, maybe in America and in England, there was kind of some kind of movement towards having a privacy law. So in 1776, John Adams wrote that it had been the British right to search houses without a justification that started this fight for independence, okay? So this was an unjustified violation of privacy. So this idea that somebody's home was kind of like sacrosanct, that people couldn't go into your home, started to be introduced into the kind of legal reasoning of the time. And, you know, in British law, this began to take kind of precedent that your home was a place where you could live without being viewed or surveyed. But really, kind of, you could see that the modern concepts of privacy that we adhere to now took a while to develop. In fact, in the Constitution that was written in America, there's no actually explicit term to reference to privacy at all. It was the Charter of Human Rights, the UN Charter of Human Rights, 1948, that kind of mentions privacy. But it was this researcher and legal mind, Dr. Alan Weston, in the 1960s. He wrote a very key book, Privacy and Freedom. Okay, so privacy and freedom, it's very, very interesting. He kind of laid down the groundwork for what really privacy is, what it means in a legal context in many, many different countries. Okay, so what kind of impelled him to write this? Well, by the 1960s and 70s, there was widespread computerization of legal, financial, medical, and other records. Okay, so you had the growth of IBM, especially after the Second World War. Many people felt that this kind of technology was ahead of the law, that it was unregulated. Computing could, you know, because of the advances in computing made during the Second World War, really the legal landscape hadn't caught up. And there was a few key cases in the 70s and 60s in America, which really kind of solidified the concept of what privacy law was. Okay, so there was a landmark Supreme Court case in the States with Griswold versus Connecticut in 1965 and Roe versus Wade. So it said that in these, the Constitution was deemed to protect. Okay, so the way that they interpreted the Constitution was that the individual's rights to privacies in the matter of the human body, including contraceptive use, etc., was enshrined in the law. Okay, so that basically, you know, you could not have this kind of information, this private information about you shared with other parties. Okay, but these were kind of echoes of what this should be, but how personal data should be used by the government or private sector still remained quite hazy. Now, this Weston argued that privacy and freedom have the right to determine how much of their personal information is disclosed and to whom and how it should be maintained and disseminated. So this was his key concept, okay? So that you should have the right to determine how much personal information is disclosed about you, how it's maintained, who maintains it, how is it spread, okay? So certain privacy laws were enacted in different countries, especially around libel cases. So for example, in the 90s, there was a lot of court cases in the UK relating to privacy. You know, people's photographs were taken and plastered on newspapers. You know, famous people. People were tapped. Their phones were tapped. People like Hugh Grant, Steve Coogan, these kind of famous actors. So that was where the legal landscape was going. But it was kind of different. It was a photographer or a powerful news agency then kind of trying to capture some of these data through very illegal means, okay, very illegal means. But the landscape that we are in now is completely different. And a lot of people feel that data is completely out of control. So just two key actors that you could kind of that are very much involved in this debate is one is this guy, the head of Amazon, Bezos, Jeff Bezos. When he set up Amazon in the 90s, he told his staff that his company was not a company that sold books. His company was a data company, a data collection company. So very early on, him and another Silicon Valley, startup founders, they realized that their value was in the data that they could collect from people. Now, it took a lot of other people decades to realize that this was the case. And really, data, people's details, has become absolute gold for companies, because with somebody's data, you can then sell this, or it can be used to market products to people. And this was kind of like a how would we put it? It was kind of a deal that people did with tech companies. Okay, so if we go on Google, it's free. Why is it free? Because Google gets to collect our data. So then that data is then used to help them target us with advertisements. It's the same with YouTube. We get to access lots of free content on the internet, but there's a price. So this was this unspoken kind of contract between people and tech companies. If you want the internet to stay free, you've got to kind of surrender some of your data. Now, with most people, they were using completely different different tech platforms they never experienced before, and human behavior changed quite substantially, so that you could then broadcast your views, your opinions, your likes, your photos, your family photos on the internet to anybody who wanted to look at them. But this has led quite quickly to quite a lot of ethical issues. So, for example, we're now seeing the first generation who are hitting their 20s, who have grown up completely, almost completely in a digital world, in a social media world. Okay, so, okay, I'll get back to some of your questions a bit later. Okay, so maybe at the end, is retargeting people? That's a good question. We'll get onto that in a second. So, yeah, so with you've got a generation that's grown up. You know, their parents would have put pictures of them on the internet without their consent. You know, there's just so much information out there. So there's been a growing unease about the amount of data that these companies have, how it's being used, how they're being targeted, how AI is involved. And then that brings us to the next person that we really want to kind of focus in on, was this guy Snowden, because what he did is he publicized the amount of surveillance that is used by governments and how they use people's data. And obviously, outside the Western world, you have countries like China who are actively using data from companies like Alibaba to profile their population and to, in some ways, punish their population if with certain economic measures. So there's talk of having, well, it's already in play, of a system where if you are not a model citizen, or you've broken the laws in some ways, then access to credit is denied. The ability to travel freely within the country is denied. Okay, so this has become quite a big concern, especially since the Snowden leaks. Now, what I'm going to do is I'm just going to show you a video, and this kind of sums up kind of the concerns. And this was a law that was introduced quite recently, or maybe quite recently, in Canada. Okay, so this is the Canadian innovation minister. His name is Minister Navdeep Bains. Okay, just going to see what his concerns were. Okay, and I'll share the sound. Okay, so this is his description of why they're going to introduce this law.
92% of Canadians have expressed some level of concern with respects to their privacy. And 81% of those Canadians want clear rules to protect their data. And 74% of those Canadians think that they actually have less protection today than they did 10 years ago. That's why we launched the Digital Charter, a set of 10 principles to guide legislative reform and policies and programs for our government. And that's why I introduced legislation today to give Canadians more control and greater transparency over how companies handle their personal information. The Consumer Privacy Protection Act. There's a few key elements of it that I want to highlight. One is around greater control, and that means that Canadians now will be able to make sure that when they go online, that the consent that they provide will be presented to them in plain, simple language, not a 30-page legal document. There'll be more transparency, and that means Canadians will better understand how their data is collected and how that data is used. Canadians will also have more control with regards to portability. That means they'll be able to take their data from one entity and one organization and be able to transfer that to another entity in another organization. And Canadians will be able to demand that their information be deleted or destroyed if they withdraw consent. And in order to make sure that Canadians can feel confident about having more control over their data, companies that do not comply with privacy legislation will have the strongest fines in the G7, up to 5% of global revenues.
So this was this was quite an interesting announcement that was made in November 2020. And the reason why it's quite interesting is because it lays out some of the reasons why governments are pushing. So at the beginning, he mentioned some interesting statistics about the unease that Canadians, for example, feel about the way that their data is used. Now, this is a growing unease. I think if you went back maybe into 2005, 2007, there wouldn't be that unease, but people have become quite savvy as to how tech companies use their data. Now, we're going to kind of look at some of the issues that he raised in that speech throughout this talk, especially about the idea or the concept of consent and the way that governments are going to use these laws and have used these laws and the effect that it will have on companies. And it's going to be very interesting for you guys as legal students, because you know, in the next couple of years, there's a lot of work really involved in this. Okay. So one of the things that he mentioned that one of the things that is quite troubling for people is that the amounts of requests for consent. Okay, I'm just going to read this. This is from a report that was given. It says the first problem is that people are so overloaded by requests to consent to the use of their data that informed choice becomes illusory. If people want to engage in the social and cultural life offered in the digital sphere, they will not be able to assess all the items or terms of service and privacy notices they see themselves confronted with. And opting out of the internet can no longer be called a real option. Okay, and secondly, privacy is no longer purely a personal matter. The information we choose to share or allow to be gathered affects not only our own privacy, but also the privacy of those we interact with. So these are the key issues that governments are concerned with, that individuals, that NGOs are. The first thing is this idea of informed choices become illusory. Okay, so oftentimes when you sign up for something, there's terms and conditions. Some of these terms and conditions are really long. For example, the terms and conditions for Apple is as long as, or if not longer, than Shakespeare's Hamlet. Okay, so who has time to sit down and read Shakespeare's Hamlet before making a decision whether to accept the service or not? So sometimes the terms and conditions are so long, there's a choice, but in reality, it would take somebody with good legal knowledge a couple of days or to sit down and read it thoroughly. So this idea of choices is illusory, and companies have used these long terms and conditions to protect themselves. And so, in fact, actually, they gave a group of legal experts terms and conditions from the top 5 tech companies in the US, and they spent 2 weeks looking at them. And at the end, a lot of them were unsure as to exactly what the terms and conditions meant. And that was after 2 weeks of study, and they were legal experts. And also, when you interact with somebody on the internet, it's 2 people involved, so it's 2 people's privacies involved, and this is another issue. So throughout modern history, from searches without just cause to big data and mass surveillance, the notion of privacy has surfaced again and again. And we're living in a particular time where privacy is a hot topic in the legal world. Okay, but the meaning of the name, the meaning of the term has kind of remained the same, but the way it's applied is different. Okay, so this is what your man Dr. Weston said. He said we must be aware of the development if we are to effectively deal with future challenges, in particular the pressing issue of the regulation of the collection, access, and use of personal information both by private and public actors. Okay, so this leads us on to the GDPR. Okay, so you probably have heard of the GDPR. You could say it's probably the biggest bit of legislation in the last 20 or 30 years for the European Union. It is absolutely colossal, its effect. And like a lot of legislation, a lot of companies have been slow to realize its impact in the way that it administrates its company and its clients, in the way that it deals with its employees, and the sheer cost of compliance. And this is quite important. So the GDPR has these principles. Okay, so basically the principles behind the GR kind of govern the rest of the rules, that it should be lawful, fair, and transparent processing. So if somebody, a company processes your data, you should be able to see what they do. There should be a limitation of purpose. And this idea is that, if you give your data to a company, which will happen in transactions, they then cannot go and use that data for other purposes. There has to be a limit. There has to be clear limits. And this wasn't always the case, especially in America. There was one company that I think they dealt with almost like 1 trillion bits of information a week or something, or a day, something colossal that they traded, 1 trillion bits of personal data. So companies have made a lot of money on trading data. So there has to be purpose limitation. Data minimalization, that really collecting data that is no way connected or useful for the company should not be collected. Okay, so only what is necessary. And this is very important. This includes data about employees, for example. So before, some of the data collected on employees would include very, very personal things, the amount of children they had, even the relation with their spouse, and things like that. So there's been data minimalization, accurate and up-to-date processing. So again, that this data, when it's processed, it's accurate, it's kept up to date. And there's and number 5, the limitation of storage in that in a form that permits identification. Okay, so again, this is quite an important one. Oftentimes, like access to your data is sometimes a little bit of a problem. Limitation of storage as well is that it won't be kept forever. Sometimes people give their details, and then 10 years later, their data is still floating around a company that might have been bought by another company with a completely different policy. So the whole idea behind GDPR was actually to build trust in companies again, because if the companies comply with GDPR, then you can trust giving them your data, and especially in lights of data breaches. For example, we had some high-level data breaches in companies like Twitter, for example. Facebook have recently had high-level data breaches. So people want to be sure that the company is doing everything possible that they can do. And this is where it comes up to the confidential and secure. One of the ways that GDPR ensures that companies are secure is through fines. So they're fined if they're not secure, but also that they have to tell their customers if they've had a data breach, and they have a certain amount of time to do this. I think it has to be reported within 72 hours to the data controller. And this is very important. Accountability and liability. And again, the GDPR does this, is that if there's a breach, you can go to the data protection commissioner in your country in Europe and make a complaint. So all these principles that guide GDPR are very, very important. They're to kind of build trust in companies, again, and to give the government more power to protect its citizens. Okay, so these are the key principles. Probably you're quite familiar with them. Okay, so what are the rules? Now, some of these rules are quite problematic. Okay, so consent. Okay, so if you process somebody's personal data in Europe, you have to give consent. Okay, it has to be informed, explicit consent. Okay, the person has to know that they're giving consent. Okay, the government can process data. Okay, for example, parking fines for car owners. So the government has a greater authority to keep data than companies do. Legal requirements. Okay, so for example, you need somebody's data if you're going to open a bank account. Okay, you need somebody's data if they're going to sign up for a subscription. Okay, you can't just use a fake name and things like that. Legitimate interests. Okay, so under the data protection law, the company has to prove that it has a legitimate interest. Okay, so for example, a credit card check before providing electricity. Contractual requirements. So if there is, again, a legal basis for this, that you provide certain data for contractual requirements. So for example, if you buy a house, for your name to be in the registered deeds in the town that you live, obviously you have to give over personal data, your passport number, your name, address, etc. And vital interests. Okay, and this is, we're going to look at this a little bit later, because this is an area where GDPR is in some ways being abused. Is, for example, during a medical emergency. Okay, so we're gonna look at this, but a lot of it hinges on consent. Okay, what is unambiguous, informed, and explicit consent? We're going to have a look at that a little bit now. I suppose consent, is it informed if you don't understand the terms and conditions? No. Is it informed if you assume consent? So before, when you went on websites, it would just have you an opt-out option. Okay, so you could, if you don't want to do this, press no. But now you have to opt in. And this is, so you'll notice that most of the landing pages for companies, when they have these cookies, before they just had I accept, but now they have I accept or manage my settings. Okay, so there has to be some kind of choice where the person can actually opt in. Okay, so it's very, very interesting. This, when people even download an app, for example, there's an opt-in. Okay, so GDPR came into effect in May 25th, 2018, and it had a huge impact on companies outside Europe doing business with people inside Europe. I remember working for an American company, and they couldn't really understand how things had changed because they were looking to recruit within the European Union. But their data was now being taken from the European Union and obviously back to their servers in America. And this then puts them under the GDPR law. Okay, even though they're an American company, they are now dealing with European citizens, and they have to follow that law. So the cookies policies had to change very rapidly, and exactly. So for them, actually doing business in Europe became a bit of a headache. So a lot of companies have gone down the route of non-engagement over the last couple of years with European Union countries, where if they're too small and they don't see that it's necessary to work in Europe, they don't. Okay. Now the GDPR has been in place since then. Very recently, the CCPA has been enacted. in certain states in the United States, especially California. And this has a huge impact on the way that tech companies are going to do their business. Okay, so what are the kind of the organization's scope for this? Okay, so any organization that operates inside or outside the European Union and offers goods and services. Okay, for the CCPA, it's to collect personal data on 50,000 plus Californian residents. Okay, have annual revenues of over 25 million, 50% of annual revenue from California residents data. Okay, so this is very particular for California. Okay, so, and it's very interesting. There's a difference. The GDPR applies to all walks of life. This applies directly to making money off the data. As you can see, if they earn 50% of their annual revenue from California residents data, okay, then they're under this law. Business service providers, third parties, and California consumers are protected and affected. In the EU, it's all citizens, businesses, controllers, processors, and data subjects. So the difference here is that in California, it's for people that interact commercially with these companies. In the EU, it's just across the board. So the GDPR is much more across the board. It's much wider. What data is within scope? Personal data of any type. And for the CCPA, it's personal data that is sold for monetary or other value considerations, releasing, disclosing, transferring, or even renting of the data. Okay, so this is very interesting. Sold for monetary or other value considerations. Okay, so again, the focus on the two laws is very different. Now, what are the fines of non-compliance? Now, the Canadian Act, if it's passed, will fine up to 5% of global revenue. We can see with the GDPR up to 20 million euros or 4% of total global turnover from the prior fiscal year for the most severe violations. So we're going to see some of the costs involved in this. Some of the fines under the GDPR have been absolutely massive. Okay, up to 10 million euros or 2% of the worldwide annual revenue of the prior fiscal year for less severe violations. So these are big fines. In California, this is more by a case by, per violation. So $7,500 per violation. Now, if a company violates the data or data privacy of a couple of 100,000 people, then obviously that could be quite expensive. So the impact on companies has been quite high. Okay, so we can see this, how many fines were given under the GDPR. Okay, so a huge amount, 216 million in March of 2020. Okay, absolutely massive amount. So we can see that there's a growing power behind this law in Europe, and it's affected a lot of companies to a great extent. These are some of the top 10 fines given under the GDPR. So British Airways, 204 million euros. Big case with Google in France of 50 million euros, Marriott International. So absolutely. A lot of them were even government companies or government-based or previous government companies like Austrian Post, which they violated data protection laws. Okay. Now we're going to have a look at just kind of the abuse of this, but just a little bit more about these fines. Why this is interesting from an Irish perspective is that a lot of tech companies have their headquarters in Ireland. So any data breaches, any GDPR breaches are processed by the Irish Data Commissioner. So the Irish Data Commissioner is actually a very busy person, and their commissioner is very busy. But there's certain kind of moves within the GDPR to wrest this control back. So if Google makes breaches EU citizens' rights in France, then the French Data Protection Agency can come after them. So this is kind of the way the law has evolved, that there's maybe less and less for the Irish data protection to do, and more for local governments, because at the moment Ireland's quite a small country, 5 million people, but their data commissioner is very busy. Now you can see the power of this. So I mean, to take like for example British Airways, 204 million of a company for data protection. It just shows you that the power that this law has and the difficulty some companies are having in being compliant with it. And it can be quite a difficult law to be compliant with, because the way that you interact with your staff, the way that you interact with your clients has to completely change. All your interfaces have to change. You have to get rid of data if you have no reason for keeping that data. And that costs a lot of money. Big companies have to have their own data protection officer that is trained and that is in the company. And they have to then train all the staff on data protection. Okay, so it's a huge area and has led to a lot of litigation. But with any kind of law, we looked at the kind of the original principles here. Okay, that it was lawful, fair, transparent, that would give people the right to privacy. But when we go back to this, we see that vital interests. With all laws, there's a way for certain parties to use this law to their advantage. Now we're going to look at a case about Poland, Romania, Hungary, and Slovakia. Recently, authorities have been abusing the GDPR to curtail investigative journalism or target civic tech NGOs by trying to force outlets to reveal their sources. So this is quite interesting, and we're going to look about how they've done this. There's a very interesting report written up about this. So the GDPR is a very, very strong law that allows a government department, which is the Data Protection Commission, to go after certain companies. So there's various reasons why this data commission could do this. Okay, so if it follows the letter of the law with partiality, then it would just look at all companies. But oftentimes the data commission responds to complaints. So a person feels that their data has been violated, that their privacy has not been protected properly, it makes a complaint. The data protection agency then looks into this complaint and then uses its power to then bring the NGO or the company to the national court. Okay, so this is all done it's a law for throughout Europe, but it is charged on a national level in the courts. And these cases can even go up to the high courts or Supreme Courts. So there is an area where there could be possible political maneuverings to use this law against certain agencies. So for example, if there's two competing companies in the country, one is a foreign company from America, one is a local company, maybe there's vested interests for politicians to protect the local company, and then people complain against the American company, and then it is investigated. This could be an avenue. Now, in Poland, Romania, Hungary, and Slovakia, there's recently been some high-profile cases about suppression of journalism. Now, obviously, journalism relies on keeping sources confidential, okay, so that they have a lead or a leak somewhere about something that the government has done. Recently in Slovakia, for example, the prime minister had to leave office because he had secretly done a deal with the Russians to obtain Sputnik 5 vaccine. Now, obviously, governments don't like this. And in these particular countries, they've been starting to use GDPR to target NGOs. Okay. Now, when it comes to the health as well, GDPR is a good tool to help officials through the COVID-19 crisis. So a lot of healthcare systems in Europe have been pushed to the brink and have had a greater interaction with the public than they have since the Second World War. So a huge amount of data needs to be processed, and these GDPR regulations have been useful in helping hospitals and health authorities process this data. However, some countries like Hungary, they felt that they have given kind of disproportionate decisions to limit the GDPR rights. Okay, so it's quite interesting how they've used that. It's also affected marketers as well. Okay, and I think this is in the commercial sector where, again, a lot of work is available for lawyers, is the compliance challenges for digital marketers. One of the most fundamental challenges has been that the new privacy laws requires a new way of interacting with the consumer. it can be quite difficult to comply with the law and, as I say, stay true to your brand experience. If you're kind of a hip happening, very modern, very up-to-date kind of company, and then you've got all this kind of stuff that the person has to do before they can even interact with you, that can be difficult. Marketers must provide consumers with a high degree of transparency and control over the data. But obviously marketers need people's data so that they can target them with advertisements and things like this. So this has been quite difficult. Okay. Yeah. So basically, yeah, there's also with the CPA, the California Consumer Privacy Act, marketers isolate consumer data where consumers have opted out. In either regime, to avoid regulatory action, marketers need insight and assurance that the proper process will be followed as their consumer data moves through the ecosystem. And this is a difficulty if you are trading on a platform, you're advertising on a platform, and then the person moves or is taken from one link to another way through the platform. What happens to the data in between this? The companies must also offer consumer data access and deletion requests. Okay, now this is quite a problem, especially for Twitter. Before, a lot of people were just worried about, okay, my data is now being shared with a company I don't want it to be shared with. But recently, with an interview with one of Twitter's compliance officers, he said another issue is that people are trying to request data, their own data, and this provides a lot of problems. One of the reasons is, say, for example, I forget my Twitter account password or get locked out of my Facebook or something. If I contact Facebook, okay, I have to provide all this data. Now, if Facebook doesn't have, or Twitter doesn't have stringent enough controls over this, then somebody who's not me can get this data and then access. So it's kind of a two-way street where you want to protect somebody's data, as in being given to another company to use to target you for advertising, but also protect enough so that somebody can't imitate you and then take your data, gain access. So there's two things going on here, and sometimes people then will file CPPA actions or GDPR actions against the company because they say they won't give me my data, and then the company will say, well, we can't give you your data until we know it's you, and you need to give us data to prove that you are the person. And there's a lot of cases like this going on where somebody wants to access the Facebook says no, and then Facebook gets taken to the data protection commissioner, and then they have to explain why. And this is causing a lot of litigation, obviously a lot of work for lawyers as well. So this is quite interesting what's going on. The kind of pushing and shoving to protect somebody's data, but also allow somebody to access it is quite impact on advertisers. Under GDPR, brands must obtain consent to collect and use data for retargeting. Okay. In the US, we haven't seen full regulatory enforcement yet, but under CCPA, advertisers must adhere to consumer opt-out preferences. The potential impact on brand equity is significant because data ethics is a big component of brand safety. So advertisers are ultimately responsible for ensuring that they're using compliant data and inventory sources. Okay, so again, a huge impact on advertisers, more so in the European area. Okay, so you actually have to consent knowingly to allow other people to retarget you. So again, this has changed the interface. Now, big news recently has been the iOS 14s. This has been rolled out recently this week. This is a device-based digital privacy reform. Okay. Now, this was taken from a really interesting article from adleaks.com. Okay, I'll post it up on the chat room when I finish the talk. It's very useful for you to go and visit this article. It explains really well what is going on. Okay, so basically, this update means that users are required to give apps permission to track them across apps and websites owned by other companies. So one of the things that, you know, you'd have your phone, you go to a place, and then all of a sudden you get advertisements about this hotel in this town or this restaurant. And that's because third-party apps are tracking your movements and then can target you for advertising. So now you actually have to give them permission to do this. Okay. Now this is a main, as I said, a main tool in the digital marketers toolkit. And this is going to have a significant impact on ad buyers and social media marketing campaigns. Okay. And we don't really know what the extent of this impact will be. So if you think, for example, Facebook, if I have my iPhone, I have Facebook on my iPhone. Facebook automatically is tracking me. I've downloaded Facebook ages ago. There was nothing there to opt out of them tracking me. You know, I'd probably have to go deep into the settings to do it. Most people don't do this. Now, whenever I use the app, I have to say that it's okay for them to track me. And there's also levels of tracking. So now with the iOS 14, you can give your exact location, general location, or city location, okay, or no location whatsoever. So for Facebook, this is a problem, because if I'm on Facebook, they can track where I am, and then they can sell this information to advertisers who can then say, well, hey, do you feel like eating Korean food in this, there's a Korean restaurant down the street. This isn't going to happen if you opt out. So this is quite interesting. Okay, and this is really absolutely brand new off the thing. I'm just going to share, we're almost finished, I won't go on too long. Just going to share just recently what Apple has done on their privacy. This is a video. Okay, so I'll give you a look at it, and just finish this 1 second. Share sound, okay.
See this. It's the new app tracking transparency prompt. It's a feature that gives you a choice.
So just start again.
When you're using apps on your iPhone, you may start to see this. It's the new app tracking transparency prompt. It's a feature that gives you a choice. A choice on how apps use and share your data. Data like your age, location, health information, spending habits, and your browsing history, to name a few. This data can help to map your runs, tag your photos, or track your location so a nearby store can offer discounts. But some apps have trackers embedded in them that are taking more data than they need, sharing it with third parties like advertisers and data brokers. They collect thousands of pieces of information about you to create a digital profile that they sell to others. These third parties use your profile to target you with ads. And they can also use it to predict and influence your behaviors and decisions. This has been happening without your knowledge or permission. Your information is for sale. You have become the product. That's why iPhone users will now be asked a single, simple question. Allow apps to track you or not? Maybe you're okay giving an app your email or location so they can share your data with others to personalize ads or build a profile about you. And if you're not, well, that's what the prompt is for. Whatever you choose is up to you. But at Apple, we believe that you should have a choice. App tracking transparency, a simple new feature that puts your data back in your control.
So this is quite interesting, because from if you just this is if you look at that from a purely innocent viewpoint, that looks like Apple are trying to really protect people's data, but there's obviously quite reasoned out. It was quite a reasoned out decision as to why they did this, and the effect that it will have on their competitors, and also what it will allow them to do in their market. Because if they would restrict the amount of advertising and influence people like Facebook and Google and other companies have on their users, well, then maybe that will help their company out in another way. But again, this remains to be seen. But Apple has done something very interesting. It's seen where the tide is moving legally around data protection. They know that people are are very concerned about how their data is used and shared and to who it's shared with. And they're kind of jumping on this, on the GDPR bandwagon, as it were, where they want to be seen to be fully supporting GDPR and CCPA. Now, in America at the moment, there's only a few states that have a kind of data protection law, California being the biggest one, but it's quite likely that there will be rolled out across the United States. In fact, some companies that are not based in California are enacting this anyway, because they can see the way that the legal winds are blowing, as it were. So obviously, with the way that companies use data, this is also going to affect the Internet of Things. So a lot of people will have Alexa, for example, in their homes, Amazon Alexa. This collects information about them. It's going to be quite interesting to see what happens within the Amazon ecosystem and how this law affects them. So this is really kind of very new stuff, as it were. So interesting to see. So finally, I suppose just to kind of sum up this talk, these new laws are going to have a huge impact and have had a huge impact on digital marketers, because they cannot access people's data as much as they were before. It has an impact on companies that have a lot to do with the public. It has an impact on government agencies as well, and how they interact. It has given people more rights to access their data and to see what data people have on them. But finally, I just want to conclude with just what I mentioned before about NGOs and how they are affected. NGOs can tend to be unpopular organizations around the world, because generally they're non-governmental, they're not influenced, sometimes not influenced by certain political parties. And so they are oftentimes bring the ire of governments because they expose things that they shouldn't. Okay, so in an interesting interview with some NGO leaders, they said that their data compliance has to be above and beyond what the data compliance is of big companies like Microsoft and Facebook. And when asked, they said, well, because we know the government's after us. So GDPR laws, not only in Eastern Europe, but also in Western Europe, are being used to create opportunities of retaliation against civic society or civil society organizations. Okay. Now this, I'm just going to just show you this example. This is from a report, and I can send the link to this as well. A small NGO that undertook an advanced and resource-intensive compliance process for all data processing operations, and only required a small scale and high risk processing. This is an NGO which holds very limited personal data and undertakes no marketing or outreach activities, engaged in this complex and time consuming assessments because they were under enormous pressure from their government. They wanted to do everything possible to avoid attracting attention. So the difference maybe between the GDPR and the CCPA is that the CCPA is more commercially orientated. And a lot of people think that this is where it should be orientated, on commercial, rather than on NGOs, whose they're more likely not to use people's data for some kind of commercial or gain. In Europe, this is, a lot of people feel is the hole in the law, is that NGOs are covered by this and that they're being pressurized in places like Hungary and places like this. Our research has also found that private companies, individuals and governments who oppose the work of an organization have used GDPR to try to keep NGOs from publishing their work. Okay, and today NGOs have successfully fought against this misuse of law. So at the moment, legal battles are happening right throughout Europe over this, that if there's an NGO that maybe publishes a report about a company that's polluting or doing something illegal or unethical, that company will then use this law to file litigation. And then again, this is an expense for the NGO. So it's being used as a stick to beat a lot of companies. So just a quick overview of some of the things that are happening very recently in data protection laws in Europe and in America. And I think the most interesting thing for you guys as I don't know if you're fourth year students or graduate students in law, is this is an area that is just going to grow massively. Most companies are hiring lawyers just to help with the data processing, because it's a very technical and difficult job. And the same is going to be in America. Most states will have their own data protection law very soon. In fact, 70 countries around the world are in the process or have enacted data privacy laws. So yeah, as a careers advisor, if I was a careers advisor, obviously data protection is going to have a lot of work for a long time. So just so that's the end. So does anybody have any questions at all, or?
Before we move forward with the question session, I would request all the participants to post their names, designation, and email ID for the certificates. Now, I would request all the participants, if they have any question, to post it in the chat box.
Okay. So okay.
Let's start with Dharini Patel's question. Is retargeting people for sales a breach of privacy?
It depends on how you got their data. So if you're the same company, so say for example, I'm a company. So say for example, I sign up for a newsletter with a company, but I don't buy anything. But they have my data on file, and then they have a new marketing campaign and they retarget, and then maybe not. That's not a breach of privacy, because I've already sacrificed my privacy signing up to them. So it depends on who has the data and how I gave that data to them, I think is the main thing.
Okay, another question from Nilang Soni. If we talk about artificial intelligence, many tech companies use this for further development of AI and IP. While we talk about GDPR, to how much extent does EU regulate from not letting tech and AI company to sell data, specifically biometric data, other than fines, since they would anyways have the data recorded in the first place?
So with the GDPR, that's a good question, actually. So obviously the fines are colossal, which is the way GDPR was set up, was that was enough of a deterrent. So 5% of 4% of global revenue. So that's really painful for most companies. And so it's more like a how should we what's the word? It's more of a preventative measure, but I think they can also enforce that they delete whatever data they have, that has to be deleted. So they can enforce that under the data protection. So if the ruling is made by a court following data protection, you must get rid of this data, then that company has to get rid of that data, and they can be raided. So there's been cases of companies being raided in Europe, so that they're checked that they're complied. I mean, when we talk about raided, they come in, they look at the computers, they confiscate computers, they question employees. So it's a very powerful law. So it's not only fines, there's that the government can actually physically go into the company and investigate them as well. And they can, eventually even, bring about different charges. So yeah, it's more powerful than just fines. Yeah.
Thank you. Question by Shreya Purani. Would you agree that infringement of digital privacy in tech-based companies may include trade secret violation as one of their major issues?
Infringement of digital privacy, trade secret violation. Yeah, that's an interesting question. I'm not sure exactly how they would go together. I mean, not quite sure how you would put those two together. I think maybe I can see maybe if you're an employee in a company, and the company now is restricted as to the amount of information it can keep about you, especially when you leave the company. A lot of companies have contracts where there's a non-disclosure agreement, so you can't disclose maybe trade secrets, etc., when you leave. But I think under the GDPR, especially, the legislation protects that because it's contractual. So generally with trade secrets, it's about contracts. Most of the trade secret leaks are because of employees that leak this. So I think there's enough of a protection under the GDPR for companies to say that they should keep this data in order to protect their company because of the contract that the person signed up to. In fact, the person would probably have had to, at the point of signing the contract, arisen the issue about, is it okay if you keep my data for the next 10 years, or that you say that I can't disclose any data about this. But yeah, I think it's pretty safe.
Question by Lakshita. Sir, as you have had occasions of being in different countries, what are your observations regarding the legal mechanism protecting digital privacy in all such jurisdictions?
Okay, so in China, there's no digital privacy. That's basically it. So it's quite scary, actually, how much is out there. And there's one dominant platform for payment called WeChat. So basically, whatever you do on WeChat is can be seen by the government. So if you send money to a friend, they know that that's your friend. If you ring somebody, they survey it. So it's a really surveillance state. And there's some parts of China which are probably the most surveyed places on the planet. So that's a very extreme where there's no digital privacy. And the social contract there is that for a lot of Chinese people, they feel that they surrender their privacy for security. And this is the idea. So in other countries, which we've seen in America, people don't want to surrender any kind of privacy or rights for the greater good. So this is kind of the battle that goes on in those two countries. We've seen it even with simple things like mask wearing, people not wanting to wear masks in America. So two completely different worldviews. And I think in Europe, it's been quite strict, actually, I would say. But you do feel a little bit more protected as to what can be done with your data. So I'd say you have China, no privacy. America, still a little bit of the Wild West. I mean, a lot of the companies don't follow any kind of privacy, digital privacy guidelines at the moment. And they're very lax about how they process data. And then in Europe, I think it's probably the most stringent. Yeah.
We have another question from Dharini. What are your views on privacy protection law in India if you had to compare it with Canadian law?
So I have to admit, I don't know anything about privacy protection law in India. But I do know the Canadian law is quite strict. I think the Canadian law, when it gets fully passed, will probably be as strict, if not more strict, than GDPR, financially anyway. But I don't really know anything about Indian privacy law.
Question from Astavlani. Sir, if you kindly deliberate on possibility of setting up international mechanism to accord protection to digital privacy, can that be a good option?
Yeah, I mean, obviously, I think that's probably the way things might move. Obviously, when the EU does something, yeah, I can see maybe eventually some kind of national. I think maybe within trading blocks, you might see this within trading blocks, but I don't think you'll see anything internationally because, again, I don't think China would ever surrender their control of data. So I can't see that happening, but I definitely think within trading blocks. So in the EU, because it's a trading bloc, it's a free trade area, having the same GDPR law just means that all companies follow the same way of processing data. And I could see maybe eventually in places like Mercosur for South America, they would initiate something like that. And then that would allow them to work in. So I can see maybe America and EU kind of having some kind of agreement as to recognizing each other's law or understanding, and maybe other trading blocks. But internationally, definitely not. I can't see. I don't think Russia would go for it as well. No.
A question from Nupur Khandelwal. In a developing country like India, what should be the right data protection approach of our government? Where on one hand, strict laws uphold the rights of consumer, and on the other hand, the same law does not let new businesses to enter into the market due to complicated application of law and resources required for compliance.
Strict laws uphold the rights of consumers. Yeah, yeah. So I think this is quite interesting, actually. Yeah. So yeah, it's kind of unfair in a way that a lot of people have built up their companies on the back of no data compliance law, so they're able to attract huge amounts of customers, advertise very easily because there was no digital privacy laws, and now anybody new to the market will have to start from a different level. Okay, so yeah, I think that's a very good point, actually. So I don't really know what the right data protection approach should be, because I think in Europe, Europe's idea for the GDPR is to protect Europe from big tech companies from the US. So you could say that they're using GDPR to allow local companies to compete. So at the moment, Amazon and Google just dominate the commercial space, and Facebook dominate the commercial space. And especially in Germany and France, governments there want to promote their homegrown industries so that they can compete with Amazon. So they feel like there's a monopoly. And in America, there's kind of talk about breaking up these tech monopolies as well. So the reasoning behind the GDPR could also be to protect European businesses and allow them to compete by restricting the amount of data that Facebook and them can use to advertise. But in India, it's a different situation where I think it's the economy is growing quite rapidly, but might not be as you could say mature economy in certain areas. So in Europe, the economy in certain areas is very, very stagnant, and it doesn't really make a difference if you come in with, if you're a new company or not a new company. I think it's a quite difficult market. But yeah, it's a hard one to answer. I don't really know the answer to that, but it's certainly interesting debate, I think. But I know definitely in Europe, one of the reasons was is protectionism. You could say it was protectionism. Yeah.
We'll take two more questions.
Okay.
So what is your opinion regarding impact of data protection and privacy regulation and related laws on fields such as digital market and data analytics?
Yeah. So this is I'll just post this in the chat, actually. If you get a chance, I would encourage you. It's a very, very good article. There's a digital marketing company called AdLeaks, and they're very up to date on what's happening in digital marketing at the moment. So yeah, this is a huge thing. So what's the impact? So digital marketing. Yeah, I think digital marketers are being left scratching their heads because it's not as easy now to mine data from people and target. It's really huge. So even on digital marketing forums at the moment, people are like, what do we do? What do we do? So some of them are kind of used to working in Europe, but yeah, it's the impact has been that they've actually, I remember reading actually one of the positive impacts is that they've been able to, there's less leads. Okay, so before you had masses of data and not all of it was good data, but now if somebody opts in to something, the targeting can be a little bit more direct. So the leads are less, but the conversion rate is higher. That was one of the things with digital marketing. So a smaller pond, but maybe bigger fish. That's how I would say. Yeah, but yeah, it's digital marketing is, I'm not an expert in, but definitely go on that website. You'll find a lot on it. Yeah.
I'll combine my question with Dave Vora's question. He's asking, how can we manage our consent? And as you has posted about iOS, do you think more companies will come up with such choices where they'll give us, if we want to give our consent further or not? Is it a good option or not?
Is it a good option to give a company your data? Okay. Yeah, I think most people have been doing it for years. I think that the key worry for most people is data breaches. Yeah, I think this is, you know, I showed the picture about Snowden. I think that's the key thing that has changed people. You've had data breaches. You've had like the Cambridge Analytics scandal. People are beginning to see that the way they're targeted with advertising and things is actually manipulating them. Okay, so, you know, if a company has a profile of you, they have all this information, then they can manipulate you even over a period of time to do something, either politically. So in America, it's used politically, but also, you know, they can have a long-term view. Well, this person likes this, this, and this, so I'm going to drip feed them over a certain period of time, and eventually they're going to become a customer. So yeah, I think a lot of people are worried about it, privacy. So I think if it was a company not in the EU, I would be more cautious about giving any data over, because I know in the EU, if there's a breach of data, you're informed about it, and then you can take legal action, and you can get you can be awarded money. So if my data is stolen, I can get some kind of legal recourse, and I don't think that you can do that in other jurisdictions, even in America. So if there's a website from America, I probably would be a little bit concerned, because if they rob your data, then they can build an identity that can be used then to defraud yourself or other people. So yeah, it's interesting. But yeah, it's interesting. In India, what's the situation with data protection law?
I think so. We are still struggling to have a better impact of data protection in India as well, because government are taking some approaches, but still there are not some specific laws to be described. So I think India is still working in that matter.
Yeah. So it's be interesting. I think it will be a growing area of law, even in India as well. In India, yeah. And I think obviously, I think the kind of, you were talking that question about is there going to be international standards of data protection? There might even be like a Commonwealth data protection, because obviously the UK is now not in the EU. So it'll be interesting to see if there's some kind of like Commonwealth data protection kind of law between Australia, UK, New Zealand, Singapore, Malaysia, India perhaps even. That could be something that could happen. Or yeah, it'd be interesting to see what happens. But yeah.
Thank you so much. Thank you so much for answering all the questions. Thank you, participants, for your questions. Now I would like to call Dr. Debarti Hadar, Professor of Law, for vote of thanks.
Okay.
Yeah, thank you, Anshami, and thank you, Dr. Browne. I was like listening to your entire lecture, and since I am also involved in research on cyber law, and this was something very interesting for me, especially for data privacy, since I've been working on cyber crimes against women and children. So thank you again for accepting our invitation and giving us such valuable information. We would love to have you again for another sessions. And thank you, Shruth, for arranging this, this much important, session, which was need of the hour. Thank you, sir.
Thanks very much for having me. Really enjoyed it. Thank you. And if anybody has any questions or anything, I'll just send my link here, so you can message me on LinkedIn if you have any questions about the talk. Yeah. Thank you.
Thank you so much, sir. I would request all the participants who has not dropped their names, please do that. Your name, designation, and email ID for the certificates.
Brilliant.
Thank you so much, sir. Thank you so much.
Okay, brilliant. Okay, so I'll say goodbye then.
Thank you, sir. Bye. Have a good day.
Thanks very much for the invite, Shruth. Thanks very much. All right, take care then. Bye-bye. Yes. Bye-bye. Bye.
How many students are there?